P.olice must stop training presumption of guilt, says High Court judge. Sir Richard Henriques' comments followed the collapse of 3 rape cases in which it was found that the police had withheld evidence from defense lawyers or failed to investigate them properly. In 2016, the former High Court judge headed a damning inquiry into the Metropolitan Police Force's mishandling of a raft of historic sexual abuse claims, in which he said the presumption of guilt against suspects had colored the way investigations were handled. Yesterday he said, "The obligation to believe all complainants at the start and automatically treat them as victims handicaps police disclosure officers in their duty to disclose evidence that assists defendants or undermines the prosecution case." This mentality is supported by the College of Policing. In order to restore confidence, police officers must be trained to investigate complaints with an open mind, understanding that a complaint may be genuine or false, and that their accused may be guilty or innocent. He rejected claims by Chief Constable Simon Bailey of the College of Policing that only 0.1% of allegations are false, branding the assertion highly dubious and saying it demonstrates a mindset that undermines confidence in our justice process. He also dismissed arguments by charities that the vast majority of survivors don't report sexual crimes for fear of not being believed, adding, "The cases that have emerged over the last week demonstrate that the burden of proof is being reversed. It's flawed. Somebody who has been a genuine victim of crime doesn't need to be encouraged to go to the police. They go to the police because they're a victim of crime." Laying the blame on the College of Policing, he challenged Home Secretary Amber Rudd to intervene, saying, "More than 16 months have elapsed since the obligation to believe complainants was criticized in my report and fully accepted by former Chief Constable Sir Bernard Hogan-Howe. Since the College of Policing is not prepared to impose a fair system of investigating sexual allegations, the time has surely come for either the Home Office or Parliament to insist that investigations are carried out with an open mind." The Metropolitan Police confirmed it was reviewing 30 rape cases following the collapse of 2 unrelated prosecutions against Liam Allen and Isaac Iti last week, with both men acquitted after the discovery of evidence that should have stopped them ending up in court. Detective Constable Mark Azaria, who worked on both cases, is said not to have passed on the contents of text messages to defense teams, claiming they were irrelevant. In Mr. Allen's case, they revealed that the complainant had told friends she wanted and enjoyed the sex she later reported as rape. Mr. Iti had been charged with the statutory rape of a 14-year-old girl, but messages showed she had claimed she was 19. Last week 26-year-old Danny K was freed from prison after serving 4.5 years for rape. An appeal heard that the complainant had deleted crucial messages from her Facebook account, claiming it was a space-saving exercise. In fact, the 29 messages, found subsequently in an archived folder on K's account, proved the sex had been consensual. Last night senior lawyers laid further blame on the way the criminal justice system had been starved of resources. In sexual abuse cases involving people who know each other, police officers seize the phones and computers of both parties. A disclosure officer is tasked with sifting through the data to determine what is relevant, and an officer in charge is supposed to ensure proper procedure is followed. The Criminal Procedure and Investigations Act 1996 makes it clear these should be separate, yet not only are they often one and the same, but often they're not specialists, said Karim Fuad QC, leader of the Southeastern Circuit, which represents 7,000 barristers. Many genuinely don't even know the code of practice. Because they're police officers, they see a piece of material and are worried it will sink their case, so fail to disclose it. Cuts in case costs also play a role. File size has become a hot potato. In this digital age, teenage girls can generate thousands of text messages and emails, he said. But prosecutors are deliberately wanting to serve as few papers as possible, or they'd have to pay counsel they instruct more. Defending counsel would also be paid more. Another barrister described how, in 2015, the CPS had to be asked repeatedly to provide text messages between a woman and the Polish defendant accused of harassing her. More than 5,000 text messages, described as unused evidence, were eventually handed over, but the CPS would not pay to have them translated from Polish. My client has insisted that he'd had a previous relationship with the complainant, while she said they hadn't. I felt the truth would be revealed in their messages. But it was only because I could speak Polish that I was able to go through them and find evidence that fundamentally undermined the prosecution's case. Oliver Kirk, a senior litigator at Old Bailey Solicitors, said, "We've been waiting for the sort of thing to happen since the rules were changed by the Criminal Procedures and Investigations Act 1996, because it relies upon a disclosure officer who is, generally speaking, the officer in the case, on his own, making decisions for the CPS. If that officer is either bent, incompetent or stupid, the whole thing falls apart. We are fighting this fight every single day of the week and in every case." A spokesman for the College of Policing said, following the publication of Sir Richard Henriques' review into Operation Midland, the College of Policing is working closely with other agencies and stakeholders to consider the recommendations in the report. A Home Office spokesman confirmed it had already begun a review into the disclosure process.